Copyright Act. Is it a good thing or a bad thing, someone asked, and the answer is it really depends a lot on your perspective. What is it? It's, the DMCA was an act that essentially added some sections to our existing copyright statute. Why was it passed? You can track it up the chain in a whole bunch of ways, but first and foremost, it was passed because the United States signed a couple of treaties that required these revisions to our copyright law. There were a couple of treaties called the WIPO Copyright Treaty and the WIPO Phonograms Treaty. WIPO is the World Intellectual Property Organization, which is a specialized agency of the UN. It is responsible for global harmonization of IP laws, so that you have uniform rights and obligations across different countries. There was a diplomatic convention where a couple of copyright treaties were enacted, and all countries who participate and who want trade benefits from each other had to enact national laws implementing these copyright treaties. So why did we enact it? Because we had to, because we had agreed to do it in the treaty. Why did we agree to do it in the treaty? Then you get into a whole bunch of policy questions about why countries enter into treaties. One big reason was that some countries made noises about whether making digital copies was actually making a copy. It's identical, it's the same thing, it's not really a copy at all. And some countries, some companies and countries that owned rights had some problems with that, thought that might not really be the best way to go, and pushed their government to insist on better protection worldwide for folks who make works. The considered judgment of all these governments was that some clarification of the law probably wouldn't hurt for that. One of the other things that the DMCA did was create some safe harbor protections for online service providers. There are provisions directed specifically to search engines that if you reproduce small amounts of material that's on a website and returning search results, that's not going to be a copyright violation. If you have caching servers, if you're a service provider and have caching servers, the copies that are created on your caching server won't subject you to copyright liability. If you host sites and people upload to them, and you have no, you can take them down if you find out about it, but you're not doing any review on the upload, you're going to get protection there. What the protection is that you cannot be liable for money damages as long as when you receive a proper notice asking you to take down the material, you promptly take it down. And the statute has a detailed list of things that are required to give proper notice. So as long as you follow the notice of takedown, you won't be on the hook for monetary liability. And online service providers really wanted that they were concerned about, can I have caching servers? Can I permit people to upload content to my site or my service? The third thing that the DMCA did was create protection against circumvention of technical measures used to protect copyrighted content. This is if you create a rights management system, a DRM system, like Fair Play on iTunes files, for example, or Microsoft DRM on lots of other kinds of files. If you create if you as a copyright owner use a DRM system to protect your files and someone breaks into that protected file, there's liability just for breaking in, separate and apart from the copyright infringement. And there's liability for making a tool that is designed to break in. So it takes that industry out of play. Now there are fights about whether creating a tool to break into it has some lawful use. For example, if you want to break in for the purpose of making a fair use of the file. I am a professor, and I have a class where I show films for fair use critiques of them. Can I crack the copy protection on the DVD in order to make a copy of the underlying movie in order to critique it? And you'll get different answers from different people about whether that should be a violation of the anti-circumvention provisions. One end of the spectrum, you've had people answering, you have a right to make a copy of a movie for critique. You don't have a right to a digital copy of the movie. Now you're deciding what form you want the copy in. That doesn't give you the right to crack the protection on it. At the other end of the spectrum, someone will say, well, all movies are going to be on DVD. How else am I going to get the movie? And it becomes a fact-based inquiry. And where the answer lies is going to evolve over time, probably, and depending on which court you land in, and a bunch of other factors. So that's the prepared stuff. And yes, on to the questions.
Well, on your last part, right now I believe Google and YouTube are in court being sued by a number of major publishers for, what, $1 billion for regularly allowing copyrighted material in substantial portions on YouTube. I just wonder how you feel about that.
Sure. Yeah, the question is, there's currently a lawsuit going on between Google and a bunch of publishers. Viacom was one of the ones that led the way on that case, charging Google with copyright infringement or complicity in it for permitting copyrighted content, movies and videos and television shows getting uploaded onto the YouTube site, which Google owns. What's the story with that? The sort of short answer, I think, is that it is a fight about who is going to bear the cost of policing. Is it going to be the rule that the proprietor of the site is required to implement some system to check for copyrighted material, or is it going to be the owner of copyrighted properties that's going to have to chase after all of this stuff? Who's going to bear the cost of enforcement? I think it's really a big part of what it comes down to. Google doesn't check whether you if you're uploading an episode of South Park, Google doesn't know at the time that it's uploaded. Is there a way for them to know, and what would it cost for them to know? Are they going to employ people to read everything or view everything that gets uploaded? There is a protection under the OSP protections that I described, the online service provider protections. If they don't know about it, Google will certainly point to the OSP safe harbor saying, if you send me a proper notice, I will take it down. That's the end of my responsibility. And the counter-argument is that it's not really that you don't know what's getting uploaded. It's that you're turning a blind eye to it. You just don't want to know because it drives traffic to your site and you make money from that. And the answer to whether it's really quite easy for them to check or whether it's not easy for them to check is a big part of what the fight's about.
Now, I should add that some outfits, apparently, publicity departments, enthusiastically submitting stuff because it's a wonderful exposure opportunity.
If you are the copyright owner and you want broader distribution for your material and you upload it to YouTube so that you can send a short link to your friends instead of sending them a file, that's fine. You're the copyright owner. You get to decide what you're going to do with it. The only issue is when you upload someone else's copyright material.